Federal shockwave. Suppressors back in the crosshairs. A silent revolution is happening in America, and it's not being televised. A federal court just reignited the national debate over suppressors, the NFA, and the limits of the Second Amendment. What started as a simple possession case has now turned into one of the most dangerous precedents we've seen in years. And to top it all off, the DOJ is shifting positions again, where the truth comes first, and your rights aren't negotiable. If you're tired of the media ignoring stories that directly impact gun owners like you, you're in the right place. Subscribe now, because what we're about to expose is bigger than one case. It could affect how every firearm, accessory, and permit is regulated nationwide. Let's break down the court decision that could either dismantle the NFA or make it stronger than ever. Chapter 1. The suppressor that started it all. It began with a solvent trap locked away in a bedroom safe. One man, Mr. Peterson, faced the full weight of the federal government over a piece of metal the ATF claimed was a suppressor. What followed wasn't just a prosecution. It became a test case for how far the government could push the Second Amendment. Mr. Peterson was investigated after law enforcement found a solvent trap during a search. He had a home-based FFL and operated a small gun business. Authorities linked his store to alleged straw purchases and improper record-keeping, but the charge that stuck was possession of an unregistered suppressor under the NFA. What should have been a minor violation suddenly triggered a national constitutional battle. Because Peterson didn't just plead guilty, he fought back, claiming the NFA's suppressor rules violate his Second Amendment rights. Chapter 2. DOJ's shocking flip on suppressor policy. Here's where the story takes a dramatic turn. While the Fifth Circuit was reviewing Peterson's case, something unprecedented happened. The Trump DOJ submitted a legal brief stating that suppressors are arms protected under the Second Amendment. The Trump-era DOJ directly contradicted past government claims. They declared suppressors are arms and cannot be completely banned, but they still defended the NFA as a shall-issue system for regulation. This triggered the court to withdraw its earlier ruling and reconsider the case. This reversal shook the courtroom. It's one thing for the defense to argue suppressors are protected, it's another when the federal government agrees. But that agreement came with a catch. The DOJ still defended the NFA's control mechanisms, just under a different legal theory. Chapter 3. The court's second ruling, a legal tightrope. After taking time to re-review the case, the Fifth Circuit issued a second opinion. While they now admitted suppressors are arms, they still upheld the NFA's restrictions. Their justification? They claim the NFA functions like a concealed carry permitting system and therefore doesn't violate the Second Amendment. The panel now accepted suppressors as constitutionally protected arms, yet they still ruled that the NFA's registration and tax structure is legal. Their rationale leaned heavily on Bruin's approval of shall-issue permit systems. They claimed that since the NFA doesn't ban suppressors, it remains lawful. Critics immediately pointed out the flaw comparing a federal tax registration law to a state-issued carry permit is a legal stretch. But this was the position the court chose, and it's now being challenged again. Chapter 4. The fight moves to full court rehearing. After losing at the panel level, Peterson's team escalated the fight. They filed for an en banc rehearing, asking the full Fifth Circuit to weigh in. Their argument? The original panel misunderstood both the law and the Constitution. Peterson's legal team argued the NFA is nothing like a shall-issue system. They stated the $200 tax is a financial barrier, not a neutral regulation. The team highlighted how this logic could justify taxing any firearm. They accused the court of creating a new pathway for backdoor gun control. This move puts the entire legal structure of the NFA back under the microscope, and for the first time in decades, there's a serious chance that suppressor laws may be overturned or deeply restricted in scope. Chapter 5. Major gun rights groups enter the fight. With so much at stake, gun rights organizations didn't sit this one out. The NRA and the American Suppressor Association both filed amicus briefs, warning the court that the ruling could lead to mass registration of all protected firearms, not just suppressors. Their brief called the panel's logic a dangerous precedent. They warned it could normalize federal registration for all arms. They rejected the idea that a federal tax equals a legal permit. They emphasized that accepting suppressors as arms should end the debate. This legal support increases pressure on the court to reconsider, because if this logic is allowed to stand, it won't stop at suppressors. The framework could be applied to magazines, rifles, and even ammunition. Chapter 6. How the Fifth Circuit became the center of the fight. The Fifth Circuit is no ordinary court. For years, it's been home to some of the biggest rulings on the Second Amendment. Filing a suppressor challenge here wasn't a coincidence. Advocates knew the stakes and chose this battleground carefully. But even in a court known for its pro-2A decisions, the panel's ruling in the Peterson case stunned observers. This is the same court that limited ATF overreach on pistol braces and 80% receivers. Judges here have issued some of the strongest rebukes of federal gun control in decades. Yet the suppressor ruling shows even friendly courts can be swayed by new legal theories. This makes the outcome of the upcoming en banc review critical for the entire movement. For gun owners, the Fifth Circuit's next decision isn't just another headline. It's a test of whether the judiciary will hold the government to the Second Amendment when the case involves unpopular or misunderstood items like suppressors. Chapter 7. What the DOJ's next move could mean. The Department of Justice has already flipped its stance once, and that wasn't a minor shift. It was a rare admission that suppressors are protected arms under the Second Amendment. But now, something else is brewing. They've asked for more time before their next move, and that's not just legal housekeeping. It's a sign of deep internal discussion, possibly even another reversal. The DOJ has until October 6th to file its response to the en banc petition. That extension request came with a key detail. They're consulting the administration on what position to take. This isn't just about the Fifth Circuit. It's about how the federal government will approach the NFA going forward. A second reversal could trigger major changes to how suppressors are regulated or expose division inside the DOJ itself. Alternatively, doubling down on the NFA would signal that the government wants to keep suppressors tightly controlled, regardless of recent precedent. What's alarming is the timing and uncertainty. Gun rights groups are watching closely because the DOJ's next filing could either accelerate the fall of suppressor restrictions or cement them even deeper into federal law. The DOJ isn't just responding to a court case. They're about to define their Second Amendment playbook for the next decade. This is a pivotal moment. If the DOJ signals weakness, it could embolden future lawsuits across the country. If they show strength and unity behind the NFA, it could crush the momentum building in the courts. That's why everyone from advocacy organizations to state attorneys is waiting for this brief like it's a verdict. Chapter 8. The ripple effect across the country. When federal circuits rule, the shockwaves don't stop at state lines. The Peterson case is already creating a ripple effect, and if it goes en banc, that ripple could turn into a tidal wave. This is about much more than one suppressor. It's about the framework judges are beginning to rely on across the nation. Courts in California, New York, and Illinois are monitoring this closely as they weigh similar cases on magazines and accessories. The Fifth Circuit's use of Bruin's shall issue permit analogy is already being echoed in other courts' reasoning. If this logic stands, it will give judges a new template to justify nearly any registration scheme as long as it's neutral or objective. This could lead to nationwide registration creep, not through bans, but through bureaucracy. Attorneys are rushing to file amicus briefs to stop this framework from becoming precedent. It's important to understand what's actually being decided here. This isn't just about whether suppressors are arms. The real question is, can the government treat the Second Amendment like a permit process? That's the threat that looms behind this case. The Fifth Circuit has been a firewall against bad Second Amendment law in the past. But if their reasoning holds, it could be weaponized in courts across America to preserve the illusion of access while burying rights under forms, fees, and wait times. The Peterson case must be understood for what it truly is. Not just a challenge to a single conviction, but a constitutional fork in the road. Either the courts reaffirm that rights cannot be taxed and registered out of reach, or they enable a new generation of slow-motion bans disguised as licensing. Chapter 9. What happens if the Fifth Circuit reverses course? If the en banc panel agrees with Peterson's arguments, the consequences will be immediate and massive. The NFA's entire suppressor regime could crumble. Registration and tax requirements for suppressors would no longer be enforceable. The same reasoning could apply to short-barreled rifles and other NFA items. Congress would be forced to rewrite the law or risk losing more ground in court. States would lose the ability to piggyback on federal restrictions for their own bans. Such a ruling would shift the national conversation overnight. From suppressors should be easier to get to, can the government regulate protected arms at all? Chapter 10. Why this battle matters beyond suppressors. This fight isn't just about one accessory, it's about whether the government can dress up a tax as a permit and use it to sidestep the Second Amendment. If the courts let that logic stand, every right, not just the right to bear arms, is at risk of being regulated into oblivion. The panel's decision sets a precedent far beyond firearms. It tests the limits of federal power to tax and register constitutionally protected activity. A win here would strengthen the Second Amendment and clarify limits on government power. A loss would encourage lawmakers to use shall-issue style schemes to regulate anything they can't ban outright. This is the moment when the future of firearms regulation and constitutional rights generally is being written. The fight isn't over yet. The fight over suppressors has moved from one man's safe to the highest levels of federal power. The Fifth Circuit now holds a case that could decide whether the National Firearms Act survives or collapses under its own contradictions. If the en banc court reverses the panel, the registry for suppressors could fall apart overnight. If it doesn't, the precedent it sets could be used to justify registration and taxation of every arm in America. Either way, this is the most consequential suppressor case in history. Stay ahead of it. Share this video with friends who need to understand what's at stake, and let us know in the comments. Do you think the Fifth Circuit will finally break the NFA's grip on suppressors or double down on the government's power? Your voice, your knowledge, and your engagement matter. Because what happens in this courtroom won't just change one law, it could change the future of the Second Amendment for a generation.